In a Fair Labor Standards Act claim, in order to be part of it, you have to opt into the case. I'll explain in a little while how that works, but you have to actively join that case under the Fair Labor Standards Act. However, with a New York labor law claim, or any other state labor law claim, you're bringing a class action, not a collective action, a class action under Rule 23 of the Federal Rules of Civil Procedure, and everybody is automatically a part of that case if you get a class certified. So the group can be much more expansive. You know, in the Alderson case that I was just talking about, we had about 40 nurses who joined the case once we sent out the Fair Labor Standards Act notice to them. However, when we were talking about settlement, we settled it on behalf of the entire Rule 23 class under the New York labor law, and then we had 160-something people who could recover under the case. That's an obvious benefit for the employees because they gain a much bigger, much better chance of recovering. It's also, and I'm not going to pretend that employers are excited about this, but there's a benefit to the employer in having this Rule 23 class brought in, which is that once there's a settlement or a judgment, that's the end for the employer, because now everybody has been satisfied, all of the class members. So you're not going to have additional people showing up with claims against you because they've all been adjudicated, whether they've been released as part of a settlement or if there's a judgment for or against the employer. They're all resolved now. So employers do have, once we start talking settlement, employers do have some incentive to include a Rule 23 class. If they feel that especially if they feel that there's going to be more claims coming, they can get it all done in one.